Hello friends, today we are going to discuss about medical professionals as an expert witness in court of law. I am Dr. Suresh Bada, Professor of Psychiatry working at NIMANS, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only, not for professional legal opinion. For legal opinion, please do contact an advocate. Conflict of interest? None. In this video, I am going to discuss about the expert witness. Defining what is expert witness, what are the standards, role of expert witness in the court of law, weightage given for the expert witness opinion, and also the tips to respond for medical witness in the court of law. And this video is targeted to doctors, nurses, mental health professionals, advocates, persons with mental illness and their family members, and also forensic professionals. Let's discuss and define what is expert witness? What is the standards which are laid down to define an expert witness? There are two important standards which have been placed. One is Frye standard, which is single. The second one is the Daubert standards. They are multiple in number. Let's discuss both of them. The first and the foremost, Frye standard for expert witness. It clearly says a court applying the Frye standard must determine whether or not the method by which the opinion was determined, that is the methodology of arriving at an opinion, was generally accepted by the experts in the particular field in which it belongs. So it's a simple standard. What it says is whether the other scientists or else other fraternity also accept the standard or the methodology applied. That is a simple one single standard which has been placed in Frye standard. However, the Daubert standards are multiple in number. Here, it is used by a judge to make a preliminary assessment of whether an expert's testimony is based on reasoning or methodology that is scientifically valid, peer-reviewed, published, accepted in scientific community, and can properly be applied to the fact at issue in the court of law. So there are multiple criteria have been placed. Let's look into those criteria. The Daubert standards clearly says 5 important criteria. The judge must look into the methodology adopted to arrive at an opinion. The technology was subjected to peer review and publication. Whether there is a logical explanation with regard to methodology, that is reliability, sensitivity, and specificity. And also, is there any possible errors and merits of scientific methodology used in the court of law? And also, universal acceptance of the standards across the community, that is scientific community, should be there. So actually, both Frye standard and Daubert standards have been discussed in the Supreme Court of India in a case Selvi versus State of Karnataka in 2010. In this case, when the discussion was there with regard to narcoanalysis, brain fingerprinting, and polygraphy, in that case, both the standards were applied. So moving further, in simple words, if we have to discuss what is an expert witness, basically, does the expert have the proper education, training, and license to practice in that area of the field? Has the expert practiced in the field of question where the case is discussed in the court of law? Has the expert performed similar investigation in the past? And the fourth, has the expert provided testimony on the subject matter previously? So these are the simple 4 points we should remember. And however, let's define it, the expert witness. An expert witness means by the virtue of his education, profession, publication, or experience, he is believed to have a special knowledge of his subject beyond that of an average person, sufficient that others may officially and legally rely upon his opinion. So that is what, in a simple way, expert witness can be defined. However, we should need to distinguish between expert witness and general witness. In general witness, the witness are allowed to provide the evidence with regard to the facts. They are not allowed to make an opinion. What the person has seen or felt, that has to be clearly told. That is called as fact, evidence of fact. However, an expert in the court of law will be allowed to make opinion based upon the logical explanation and scientific methodology applied. So opinion can be given by an expert opinion. Let's understand how this expert witness plays a very important role through a case vignettes. One of the case vignette which is well known across the world is by Sir Samuel Roy Meadow. He is a well-known celebrity British pediatrician. He is a scientist, he is a researcher, he is a pediatrician, clinician. He has won many awards such as Donald Patterson Prize of the British Pediatric Association. He also coined the term Munchausen syndrome by proxy in 1977. This is basically, if you remember, Munchausen syndrome is a syndrome where a patient goes to the hospital repeatedly by saying that he has some medical illness. He undergoes investigation and he gets admitted. Many times they do undergo surgery also. Whereas the problem is psychological conflict, not the medical illness. However, Sir Samuel Roy Meadow came up with this Munchausen syndrome by proxy, where a mother subjects her child to multiple investigation, multiple tests, and also treatment, where here the mother is putting the child at risk. Please do remember, Munchausen syndrome by proxy is a situation where mother is seeking attention from anybody, and finally they get attention in the hospital. However, Sir Samuel Roy Meadow also played a very important role in an important SID, that is sudden infant death syndrome, also called as Scott's death. He had written multiple books, and one of the books he clearly said, the title of the book is ABC of Child Abuse, that in a single family. In that book, he clearly said, in a single family, if one sudden infant death is a tragedy, 2 is suspicious, 3 is murder until proved otherwise. This quote became a law that was considered as Meadow's law. In UK, this was used widely in various courts. And also, Sir Samuel Roy Meadow gave expert opinion in various cases. And there are important 3 cases which defines this Meadow's law. Since Sir Samuel Roy Meadow was an expert witness in sudden infant death syndrome cases, one of the landmark cases is Sally Clark's case. Here she is a lady who has given birth to 2 children. One child died at 11 weeks, which was sudden infant death, and the other one died at the 8th week. In both the cases, Sally was accused of killing the children, and Sir Samuel Roy Meadow had given the opinion telling that 1 is a tragedy, 2nd is suspicious, and 3rd is a murder. Based upon Sir Samuel Roy Meadows, she was convicted. Similarly, another case, Angela Cunning's case, 2 children also similarly died. The 3rd one was Trupti Patel, a pharmacist accused of killing 3 of her babies. In all these cases, Meadows' law was used. However, Sally Clark's advocate challenged it in the Supreme Court of UK. And this challenge was accepted in the Supreme Court, and Meadows' statistics, basically based on the Meadows law, which said that 1 infant death occurs, that is sudden infant death occurs, 1 in 7.3 crore population. However, the defendant lawyer advocate vehemently argued and also accused of applying something called as prosecutor's fallacy, in which the probability was completely wrong. And however, Sir Samuel Roy Meadow could not produce any statistics. And hence, there were 3 important points which went against Sir Samuel Roy Meadow's expert witness. One is cause-giving effect, that is, the true likelihood of a suspect's innocence. Here, if a person has committed a crime, the state has to prove that he has committed a crime. Here, cause-given effect. Here, the complete blame is on the mother. The mother has lost 2 of her children, but now she has been accused. Similarly, second one is effect given cause. The probability that an innocent person would lose 2 children in this manner. In a similar modus operandi, is it possible? So this was the question. And finally, in the murder, especially double murder, is it itself a rare event? And the null hypothesis is a natural death. Unfortunately, in the Meadow's law, the null hypothesis was rejected. The researchers' Meadow's law was upheld. Hence, when it was challenged, Meadow sir was called back to the court and was grilled. Invariably, Sally Clark was released and the appeal was upheld. But Sally Clark, when she was released from the prison, within 2 years, she started using alcohol and unfortunately died. Here, Sir Samuel Roy Meadow lost his GMC registration for his expert witness, and his law was widely criticized. Hence, my dear friend, please remember, whenever you are giving an expert witness, it should have scientific temperament, it should have reasoning, and you should ready to acknowledge and ready to reveal the methodology applied and be ready for the scrutiny, and also withstand the either maybe the defendant side or else it should be able to withstand the scrutiny of the opposition lawyer. Now moving on to the Indian Evidence Act. Because expert witness are brought under the Indian Evidence Act of 1872. Indian Evidence Act of 1872 section 45 clearly states that when the court has to form an opinion upon a point of foreign law or of a science or of an art or to identify of a handwriting or finger impression, the opinions upon that point of person, especially skilled in such foreign law, science or art, or in question as to identify of handwriting or a finger impression or relevant facts, such person are called as experts. This is what the Indian Evidence Act of 1872 defines. Let's now move into medical expert witness. Under what circumstances the expert witness are called, especially with regard to medical profession? First and the foremost, age of a person, postmortem report, cause and time of death, nature and effect of the disease or injury, manner in which injuries are occurred or caused, nature and time of injury, wound certificate, sexual abuse examination. Not only that, there are certain issues which need to be expert opinion is required, especially with regard to mental illness, mental capacity of persons with mental illness, capacity to commit a crime, capacity to execute a contract, that is testamentary capacity, insanity defense, mental illness, marriage and divorce with regard to giving an opinion, certification of mental disability, and fitness to duty. So there are various areas where the doctors or the medical professionals can be called upon for expert witness. Moving further, we'll discuss one of the Supreme Court judgment in which expert witness has been defined. Here is one of the 60-year-old male who had a back pain and later diagnosed to be having cord compression at D4 and D6. It was a pot spine. He was operated on 25th 11/1995, but operation failed. He was again, expert opinion was taken and he was reoperated on December 1995. Unfortunately, the symptoms worsened. And again, the opinion was taken from Viman's New Delhi. In this case, the Supreme Court clearly said that expert is not acting as a judge or jury. That is the first point what the Supreme Court said. Expert is not acting as a judge or jury. An expert has to show that he has made a special study of the subject, acquired special experience therein. In other words, that he is skilled and has adequate knowledge of the subject. That is what the Supreme Court defined. Although Indian Evidence Act gives a vague definition, here the Supreme Court tried to define expert witness by telling that they should not act as a judge or a jury, but they should had done special studies in the subject and have acquired special experience in that area. Further, there are 4 tests which have been discussed. The 4th test is, first and the foremost, is expert educational background is very essential. Second test is the experience of the expert witness. And the 3rd test is readiness in details of techniques, procedure, logical explanation, and ready to withstand the scrutiny of the cross-examination. That means the expert witness should lay out all his techniques which he has used in the court of law. And finally, the conclusive test is that expert is conservative, conscious, helping the court to come to a conclusion that it should be of justiciable. So here, these four important points have been discussed. Let's now understand. We have discussed about the expert witness. What is the weightage given for medical expert opinion in the court of law, especially in India? In India, various Supreme Court judgments have clearly said that Indian medical evidence can be taken as a corroborative evidence. It's not a substantial evidence. It is a corroborative value of evidence. Please remember. That means I can call it as a circumstantial evidence, or else it is a corroborative. That means there should be all evidences, and this expert opinion should go along with the link, along with the case. That means the court either can take the expert opinion's opinion, or else it can just discard it. Hence, an expert witness is not a witness of fact. It is evidence, more of advisory in character to the court. That means expert opinion just is advisory in nature. It is left to the court to accept or not to accept the expert opinions in the court of law. The duty of the expert witness is to furnish the judge with the necessary scientific criteria for testing the accuracy of the conclusion, so as to enable the judge to form his independent judgment by the application of this criteria. Here, expert opinion would have not attended the case, would have not seen the case, but he can form an opinion and help the court with giving a logical explanation, with scientific temperament, positive and negative aspect of the opinion, and help the court to come to a conclusion. That means here expert witness should not be either on the side of accused or defense. He needs to provide all information possible to the court of law so the court can come to a conclusion. Now move into another important discussion, that is Malay Kumar Ganguly versus Sukumar Mukherjee 2009. The Honorable Supreme Court has answered this question. In this case, it clearly says, court is not bound by the evidence of the expert because the expert opinion is largely the extent of advisory in nature. That means the Supreme Court was very categorical. That means the court can either accept the expert opinion or else it can reject. It is left to the court discretion. So my dear friends, expert witness, don't feel just because you are given an opinion, the court will go in favor of you. Because expert opinion can come from on the other side also. So it is left to the court looking into the case at large, available evidences, witnesses, and if the expert opinion also goes in that direction, it will be accepted. Otherwise, it will be rejected completely. Hence, the court have a full power to derive its own conclusion upon considering the opinion of the expert, which may be adduced by both sides. Hence, expert opinion could be admitted or denied by the court. Let's understand the process, how the expert witness is taken into the court of law. First and the foremost, if the expert has examined certain materials or he has examined the patient, all those medical records which he had submitted to the court, he should go through that. He has to testify under the oath that he is telling the truth. That means oath is required. And there will be examination in chief by the advocate who has summoned the expert witness. There will be cross-examination by the opposite lawyer. Re-examination will be done by the summoned advocate. Sometimes the judge can also questions to the expert witness. And finally, evidence recorded should be signed in each page by the expert in the court of law in India. To consider to be an evidence in the court of law, the doctor certificates or medical record or any prescription or any piece of paper from any office need to become an evidence. Means it should be testified under oath. The person has to recognize his signature, and also the document should withstand the scrutiny of the cross-examination in the court of law. Then only it will be considered as a evidence. That means it becomes expert evidence, expert opinion. Simple rules for certification. Coming to the last part of my presentation. If you are certifying as a doctor to a patient, What are the simple things you should need to keep in mind? Whenever you are addressing to a court, address to the court, not to a judge. You have to say such a court. Don't name the judge because this is official letter. Use simple words. Avoid ambiguity. If you want to give an opinion, you may have two opinions. You may give points in favor of first diagnosis, points in favor of second diagnosis. Be to the point. Whatever the court has requested, give crisp and it should be point. Avoid technical terms and have appropriate knowledge what you are certifying. Evidence justify your findings. That means you need to be ready to provide evidence, logical explanation for your opinion. You need to signature with name and date. Put a copy of the certificate in the file and post it to the court. And also remember there are certain general guidelines before you certify when that certificate goes to the court. Whenever you are doing a certificate, read all the accompanying letters from the court. It may be from the court, it may be from the advocate, it may be from the employer. Read all them thoroughly. Know what you should do. Make sure what is your job. Why this person is standing in front of you. What does he want? What are the possible scenarios, the legal conflict which can come into the court of law? Do not have prejudice, but keep everything in mind. Do a thorough general physical examination. Do a proper identification mark. Nowadays, you have Aadhaar card. Please do enter that because many a time the case will come after 4 years or 5 years into the court of law. You may not be able to remember them. Having the Aadhaar card, a copy of the Aadhaar card, the number will be able to identify the person. If you have done investigation, please look into those investigation, make a summary of that. Name, signature and date it please in every page if you have done the examination. Now moving to the summons. You have done the examination. You have given the certificate to the court. The court will send summons at any time. Invariably, it will be summons. Many a time, if the court is in urgent or else the police may not deliver the summons. At the third time, they may come and knock your door with arrest warrant. Most of the time, these summons are untimely for medical professionals in India. Many a time, the doctors will be doing various jobs and at that time, these summons come untimely. And as I mentioned, sometimes the police may not deliver the summons and they come up with arrest warrant. Many a time, when you get this, don't be angry, don't get frustrated. Talk to the police constable. Ask him from which station, what is the case about, what is the case number, is the medical records available, is there any prescription available, whether there is a certificate available, which is the court, what is the date. Take the number, phone number of the advocate who has summoned you. At the same time, know where the case is. Many a time in the metropolitan cities, there are many courts you do not know. When you reach late, and sometimes you may not be able to find the court. Hence, take the police number and also the court's number where you have to go, and also have the copy of the summon. Sign that summon and give it to the police. Immediately after that, trace the medical record in your hospital. If you have a register, make a copy of it. If you have a copy of a medical record, please do have a copy. If possible, take 2 copies. One you may have to submit to the court. Another one, keep it with yourself because many a time you have examined and those files will be submitted to the court of law and many a time it will be forgotten. When it is appealed, many a time the higher court will call you for evidence. At that time, the spare copy will help you. Go through the records completely. If possible, prepare notes. At the same time, look for medical records. Look for other medical treatment outside your hospital. If possible, talk to your seniors. Talk to the legal experts. They will guide you. No need to be anxious. Here, you are an expert opinion. The court will decide whether to accept your opinion or not. Your opinion is just advisory in nature. It is corroborative evidence. It is not a substantial evidence. So no need to worry. You are not on trial. Be as truthful as possible to the court of law so that the court can arrive at the decision. And tips to responding to the court. We have now reached the court. How to respond to the lawyer? Listen to the question carefully. Once you have listened, think and respond. When you are responding to the judge, you have to say sir. If possible, if you want to say honorable, that's also fine. But I prefer to say sir. Do not get caught in this question, yes or no. Invariably in cross-examination, the advocate will force you to answer in yes or no questions. In such a scenario, many a time, you have taken a oath to tell the truth. And some questions cannot be answered in yes or no. In such a scenario, do not look at the advocate, look at the judge and tell them, sir, it cannot be answered in yes or no questions. I'll not be able to comment. If the court gives me permission, I'll be able to explain it in detail. Because many a time, yes or no questions will abort the justice. In such a scenario, you have to look at the judge and request for opinion to be explained. In case of difficulty and you have problem, ask the judge to give time. You may take a break or else a new date with the preparation you can come. Do not become emotionally charged in the court of law. You are not on trial. Many a time some stupid questions will be asked in the court of law. Once in the court of law I was asked, you have taken money to give this opinion. So suddenly you may become angry. It is not so. It is a court the way it is functioning, and they will ask, you have taken money to give this certificate. You should say no. By chance, if the hospital is collecting money for giving the certificate, you can say yes, the hospital has taken money, so it's so much charges for the certificate. That means the charge is for the time, for the opinion. The certificate is not for sale. Remember, please remember this. You are an expert opinion. Your opinion is just an opinion. It is in the court of law, it is considered as a corroborative evidence, circumstantial evidence. The court will decide whether to take it or not to take it, your opinion. Further, if you do not know answer to certain questions and you have not examined certain areas, tell to the court truthfully, I have not examined, I do not know the answer, needs further examination, certain facilities are not available in your hospital. Please be truthful and tell your limitation to the court so that the court can come to its opinion. And last but not the least, be careful responding to the percentages, ranges, and statistics. Unless you're damn sure, don't talk about percentages, statistics, and range. As I mentioned, in the Meadows law, the percentage went wrong. That should not happen. Unless you're damn sure, don't have this percentage, statistics in the court of law. If you want to do that, carry a standard textbook and quote from the textbook. I'm quoting from this textbook, author, edition, page number, line, and paragraph. Quote that so that the court knows that you are using that quote from a standard textbook. And also, be careful responding to the conclusion of the colleague or students or the mental health staff or nurses. This is common in teaching hospitals. Most of these medical legal case files will be written by the doctors, students, trainees, nurses, nursing trainees. You have to be very careful. Please have an SOPs. Who is going to enter into the medical legal file? Who will not enter into this? And who will have access to these files? So please be careful when the opinions will be asked. In one of such a similar situation, what happened was a patient was brought to the hospital from the prison. And in the OPD, one of the junior resident made severe depression. After this junior resident made the diagnosis of depression, it was discussed with the senior resident. Senior resident made adjustment disorder. And finally, when it went to the consultant said, let's keep the diagnosis open. We will admit and examine. Within 2 days of admission, the person was jovial in the ward and he was laughing playing, everything was normal. When we asked him, he said, I wanted a change of place. Hence, I came to the hospital. That means the adjustment disorder was wrong, depression was wrong. The consultant was very clear to admit and examine. And when this case file goes to the court of law, the advocate will definitely ask, see, your junior resident has made a diagnosis of severe depression, and your senior resident made as adjustment disorder, and you are mentioning as malingering. Which one is correct? At that time, you have to be very careful and you have to respond. I'm here to give my opinion from the angle of what I have examined. I do not know how the junior resident who is a trainee and senior resident who has less experience has given that opinion. It is left to the court to decide to accept your opinion, or else they may summon the junior resident, or else they may summon the senior resident to give opinion what they have examined. So my dear friend, please be careful who is having access to the file, who is writing in the file, who is making conclusions in the file, and what is the discharge summary. So be very careful. So whenever you look into the medical file, go through the medical file as a consultant thoroughly. Once you are deposed, sign in all pages, ask for attendance certificate from the court, and sign all the pages of evidence. Coming to the end, please remember Section 45 to 51 of the Indian Evidence Act discusses about expert witness. The expert witness is an opinion given by the expert. Hence, it is considered as corroborative evidence. It is not a substantial evidence. That you should remember. Mere submission of opinion by an expert through any certificate or any other document is not sufficient as an evidence. It has to be submitted to the court. It has to be testified under oath. And then it should withstand the scrutiny of the cross-examination. Further, the opinion should also have a logical explanation. What are the methodology adopted? What is the basis for forming this opinion should be discussed in the court of law to be accepted as expert opinion. To conclude, my dear friends, the evidence of an expert is not a substantial evidence. It is just a corroborative evidence. The court do not consider the expert opinion is conclusive. It is just a corroborative. Without independent and reliable corroboration from other witnesses and other evidences, in the eye of law, expert's opinion is just an opinion and a corroborative evidence. Thank you very much for giving your valuable time. Stay safe.